Just a few weeks ago, the government's cuts to legal aid in civil cases came into effect, with public funding no longer available for most family, employment, immigration, housing, and many other areas of law. Over 620,000 people, according to the government's own estimate, will now lose out on free legal aid in difficult economic times, just when they're most needed. But apparently that's not enough, and this government are now turning its attention to criminal legal aid, or price competitive tendering, PCT if you will. Over the last 25 years, legal aid rates have been cut so savagely that the number of firms practicing in England and Wales is now 1,600. Now compare that to 11,000 back in 1998.
We've seen a series of changes to how we are paid, such that today legal aid law is paying much less than it would have done 5 years ago and much less than it would have done 10 years ago. There's been a consistent downward trend cutting the rates, and anyone who hears talk of fat cat legal aid lawyers is really picking up on what you could call government propaganda. It's a bit like saying that all footballers are paid what David Beckham earns, and likening him to people playing football on a Sunday morning on Hackney Marshes.
Many of them earn very low salaries and wages. Many of them haven't had a pay rise for many, many years. All of them are committed to public service, and to demean them and offend them this way is wrong.
For some time, solicitors, barristers have been offering first-rate services on second-class fees.
And a lot of firms, as a result, have decided not to do legal aid work. Some firms have found that they've been able to survive by bringing in other forms of revenue. Our firm does some private work, and that is essential. Effectively, it subsidises the legal aid work that we do. Another model for how people can make legal aid pay is to take on ever less qualified staff, and the balance of staff in your business changes, so that in that model you're going to have a factory type system where solicitors might supervise unqualified staff. That's actually the model that the government would like. It's been around as a theory for a while, and they seem to think that that would be a good way of delivering the service. But those of us who work in it know that you can only use unqualified staff to do so much work. If you remove solicitors from the equation, mistakes get made, and in the end that isn't efficient, it's not good for justice, it doesn't save money, and it doesn't work.
Now, this coalition government are taking it one stage further. That the lawyers that offer you advice now are doing it because they have offered the lowest rate.
The effect then of these proposals is that you will in due course have quite large factories offering legal aid criminal defence services, with many unqualified staff making decisions and providing advice on your case, and no matter how good or bad the advice is and how willing or unwilling they are to do the job, you will be stuck with them.
In most cases, the government propose to pay lawyers the same fee whether their client pleads guilty or not guilty. Now, this could lead to an appalling conflict of interest as far as lawyers are concerned, making it expedient perhaps for a lawyer to advise a client to plead guilty early on, so that it reflects better on the profit and loss account.
It's as if the author and the Secretary of State don't understand how the legal system works. There will now be a perverse incentive for a lawyer to advise his or her client to plead guilty, because the amount of monies they would receive if they pleaded not guilty and it went to trial would be the same. And that's a real concern, because a client sometimes disillusioned, disenfranchised, very often lacking confidence in people in positions of power and influence. If he or she doesn't have confidence in their lawyer, I question the ability of that person to receive a fair trial.
Small wonder it is that the former Lord Chief Justice, Lord Wolfe, recently added his name to a whole list of experts who say that if these proposals go through, it'll lead to systemic miscarriages of justice. But that's not all that's wrong with these proposals. Accredited law firms will drop from 1,600 to barely 400. And on top of that, criminal suspects will lose the right to choose or dismiss their own legal representatives. We still have a right to choose our own doctor on the National Health Service, or the school where we have our children educated. But in this country, if you're prosecuted, you don't have the right, if these proposals go through, as to what solicitor you will have to represent you. Solicitors used to compete on reputation and quality of service. If this government has its way, that choice to put our trust in who we're comfortable with will go. Indeed, trained lawyers could be completely taken out of the equation altogether if the government have their way. And we'll have ourselves represented by private companies from start to finish in the criminal justice process. They'll represent you in court, help to lock you up if you're found guilty, and rehabilitate you once you get out. These proposals have come about because the government want to save money wherever it can. And cutting legal aid for criminal suspects is one of the few cuts that's actually got a measure of public support. But whatever the coalition may say about the last Labour government spending too much, the fact is that past administrations, be they Conservative or Labour, cut and cut again legal aid, even when the economy was booming.
I worry that an unintended consequence of these changes are many lawyers will go out of business, our judiciary will become less diverse even than more, clients will lose their freedom of choice. Look, in every other sphere of public service we're trying to increase the choice that citizens / consumers / customers have. Yet here we are reversing that. That's an example of a Lord Chancellor in a rush to make headlines, not taking time to consider the consequences of his policies.
The government say that they are intending to save approximately £200 million. In fact, the government are not being completely clear with the figures that they've provided, because a large wave of new cuts were brought in the last couple of years. We've seen fixed fees in the police station introduced. We've seen a whole new system for Crown Court fees and how they're paid, and reductions in those fees. And the projected costs, which we have been waiting and asking for a long time, suggest that the government may already have saved the majority of that 200 million.
The paper's been published and the government's making up its mind before the Chancellor has even set out his plans for the spending review in June of 2013. So what the Chancellor will do is come to Parliament and set out his plans for the next 3 years. But you've got a Lord Chancellor so keen to impress the Prime Minister and Chancellor, he's come forward in advance with cuts. What he should be doing is arguing the MOJ corner. What any Secretary of State should be doing is going to the Chancellor and arguing why his or her department needs investment, and if there are cuts to be made, of course offer up cuts and savings, but do it in a coherent manner. And I worry about the consequences of a Lord Chancellor in a rush to impress.
Opponents of these proposals are now galvanising their resources after the government quietly announced their plans on the day Baroness Thatcher died. The consultation paper closes on the 4th of June. This gives us barely 3 weeks to get our message across and to fight to save justice.